in item 33, reserved for judgment. I have everything. No, I'm fine. Fine. Let's check corridor. Just have a look at it. Did you? Mr. Gautam, I think you had also given something.
Also, we have submitted PCBS, submitted a lot.
So just check if everything is there or not. And Mr. Gautam, if you have a minute, in your presence, you clip it with a blinder's clip. And it will all the written arguments. Yes. Here also, I think everything has been filed.
The only thing which my senior wanted to present before your lordship is one judgment of Suraj Prakash Gupta.
This one, I can do one thing, Mr. Sinha.
Yes, sir.
I can have this matter fixed on Thursday through video conferencing mode because I'm not going to be holding court from here. Next week, I'm going to be at Aizol. So I'll fix it at 2 o'clock video conferencing mode. And I'll see if Mr. Chaudhary wants to say something, he can say on that date. Otherwise, I'll close it on that date or give the order on that date itself.
Place just two judgment before which Mr. my senior has just.
All right, on that date, I'm putting it on Thursday. Huh? If you want to say something, you say it. Otherwise, Ms. Counsel, you appeared in a wrong in the first matter. Are you there? Is Mr. Nayak there in the first matter in 33? You are there. 33 is reserved, Mr. Nayak. 30, huh?
I have found
33, right? Yes, it is there. Have you checked? 33 has been reserved for judgment. And 34, 35, 34 and 35 list on Thursday date on such and such date through video conferencing mode for further hearing.
At 2
I'm not going to be here. The only you see, they have just submitted 2 judgments. Please give them a copy also. You have a look at it, Mr. Nayak. If there is anything, you can say it. Otherwise, I'll close it on that date. I think to that extent, these 2 judgments have been given.
No, that was earlier judgment. That was.
So you asked Mr. Chaudhary if he wants to say something on that date.
The only thing is that these 2 judgments which are subject to your lordship, these 2 judgments categorically states this was the evolving of the law at that moment of time, that the service conditions, that the rules of recruitment cannot be relaxed. It is only the conditions of the service. If the lordship kindly looks
paragraph.
Suraj Prakash Gupta, paragraph 26, 27, 28, 29, 31 and 32.
31 and
32.
And the other one?
In this judgment, it has been categorically stated that in fact, relaxation is bad in law.
And Bhupendranath?
And Bhupendranath Hazarika, your lordship, that judgment is your lordship, para 58 and 59.
58 and 59. All right, Mr. Sinha, just with a pencil or a pen, just put that one line as what is, for what context you have given this, Mr. Gautam.
I'll place it.
And
rule is still.
I have posted it on Thursday, right? Tulangi, Thursday. Make it Tuesday.
At 2 p.m., your lordship.
Not this Tuesday. Next, not next week Tuesday. That will be, huh? Yes. On 28th at 2. All right. Yes, where is that bail matter? Error scan copy, yes. SC Kayaler কামাক থাকিবলৈ কৈ দিয়ক ইয়াত। Heard Mr. PP Mehdi.
G. Borgeri on behalf of PP Mehdi.
Huh?
G. Borgeri on behalf of PP Mehdi.
No, but the argument was by Mr. Mehdi,
Yes,
right? Heard Mr. PP Mehdi, learned counsel for the petitioner. Also heard Mr. S.E. Kayal, learned standing counsel NCB, within brackets, special public prosecutor. This is an application under section 483 of the BNSS 2023 seeking bail to the accused petitioner, i.e. Gautam Rai, who was arrested on 17/6/2021 in connection with NCB crime case number 12/2021, reference special NDPS case number 29/2021 under section 8 within bracket C, read with 20 B3C and 29 of NDPS Act 1985. Stop. Mr. Counsel, you may take your seat. The brief facts of the case is that on 17/6/2021, a written information was received from a reliable source that 3 persons, including the petitioner, will be carrying a huge quantity of ganja concealing it in a truck bearing registration number HR 55K5550 and will be arriving at Baihatya Chariali Kamrup Rural, Guwahati between 21:00 hours to 23:00 hours. Stop. These information, so you will find at page 3. Cross check. Accordingly, a police team was authorized and sent to the location. And after reaching the said location, they intercepted the suspected truck in presence of independent witnesses. It is further alleged that there were 3 occupants in the truck in question, including the petitioner and upon thorough search, a special cavity upon a thorough search of the vehicle, comma, a special cavity was found behind the cabin of the truck, and upon removing the cavity wall, total 23 packet of suspected ganja, which was covered with black polythene and underwall, was further covered in paper and also further bended with polythene rope. And further worse. Just be there. I'm dictating the order. It was kept for delivery today. It was suspected that the articles were were ganja and loaded from Senapati in an area after crossing Senapati police station of Manipur. Thereafter, the suspected ganja was tested and found to be positive for the test of ganja, and the 23 packets of ganja weighed approximately 236.29 kgs. Accordingly, the contraband articles were sealed and seized. Thereafter, a case was registered. Expire. Accordingly, on 19/6/2021, the petitioner was arrested when 17/6, not 19. Here you have said it 19. I think that's a mistake. Accordingly, the petitioner was arrested. Don't say the data. Was arrested and forwarded before the jurisdictional magistrate court. SDJ, jurisdictional magistrate court. Accordingly, the present bail application. Stop. Mr. So-and-so Mehdi, learned counsel for the petitioner, submits that the petitioner has been languishing in jail for the last 3 years, 10 months, 19 days. Correct? He further submits that the trial is proceeding in a snail pace speed, and out of the 9 prosecution witnesses, only 2 has been examined till date. He further submits that the trial having been delayed, the fundamental rights of the petitioner under Article 21 of the Constitution is infringed, and therefore the stringent provisions of Section 37 of the NDPS Act cannot be made applicable in the instant case. Per contra, Mr. S.C. Kayal, learned special public prosecutor, submits that ইয়াৰ ডিচিশনছবোৰ আছিলে ক'লৈ গ'ল? হেৰি এই ফাইলটোৰ পৰা কিবা উলিয়াইছিলে নেকি? এনেকেতো আছিল। আচ্ছা। Submits that the contraband articles having been possessed from the possession of the petitioner. Why conscious? He was in the truck. You want to further damage your case? Then I can. Huh? Then why conscious you are bringing? He was inside the car. He was there or not inside the car? Then from the possession of the vehicle and therefore, sorry, Mr. Counsels, please don't unnecessarily interrupt the court when the court is dictating an order. This is very wrong because you are unnecessarily interfering the flow of the judgment. If it is even a judge is human, so there could be some mistake. You have a pen, you have a paper, just write it down. Once the judgment is over, dictation is over, you point it out. From the reframe it like this. Mr. So and so submits that since the contraband articles have been seized from the vehicle in question, which was a vehicle in question, while the petitioner was inside the vehicle, there are reasonable grounds to believe that the petitioner is guilty of the alleged offense. He further submits that possession being established, the rigor of 37 NDPS Act is applicable and therefore bail ought not be granted. He further submits that when possession is established, prolonged delay would not make the statutory provision of Section 37 NDPS Act obsolete in such case. He further submits that there are implicating materials available on record against the petitioner. He further submits that CRPC CRPC. He further submits that under Section 436 capital A of the CRPC, where a person during the period of a trial under the code of an offense has already undergone detention for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under that law, he shall be released by the court on his personal bond or with sureties. He accordingly submits that what is the maximum punishment here?
20 years.
He accordingly submits that the maximum punishment for the alleged offense against the petitioner being 20 years. In view of section 436 capital A, bail ought not be granted. Oh, sorry. Yes. I have given my prudent consideration to the arguments advanced by the learned counsels for the contending parties and have perused the materials available on record, including the scanned copy of the case records received from the trial court. I have also duly considered the citations submitted at the bar. In the present case, it appears that the petitioner is the owner of the truck from which the contraband articles were seized, and that he was also traveling in the said vehicle along with the other two co-accused while the contraband articles were found. It further appears that the contraband articles, don't say that, huh? Yes, Mr. Counsel, when was the charge framed? Do you have the date? It appears that the petitioner was arrested on 17/6/2021, and upon completion of the investigation, the investigating agency submitted final complaint within bracket offense report before the trial court on 13/12/2021. When did the court frame the charge? You have that date? Yes. What was the date? I said what was that offense report date? 13, 12, 21. No? Thereafter, the trial court on, you correct me if this is wrong, the date, please. On 23/12/2021, framed charges against the accused, against the petitioner and against the petitioner, and the trial accordingly commenced. Stop. It appears that out of the 9 prosecution witnesses, only 2 prosecution witness has been examined till date. It further appears that the petitioner has been languishing in the jail since last 3 years, 10 months, 19 days, approximately. Pertinent that where upon careful scrutiny of the order sheets of the trial court, it appears that on a number of occasions, despite issuance of summons, no prosecution witnesses had turned up for giving their depositions. In fact, the first prosecution witness was, in fact, the first prosecution witness gave his deposition on 8/8/2023. Pertinent to refer to the order of the trial court dated 22/12/2023, wherein the trial court has seriously taken note of the fact, has taken a serious note of the delay of the case due to the fact that despite one prosecution witness having last recorded on 8/5/2023, there was no progress in the case. Since the remaining prosecution witnesses were not turning up on the dates fixed to give their deposition. In fact, the trial court also observed in the said order that two accused persons are in jail facing trial, from the jail, and accordingly directed the prosecution to take serious note of the delay and produce the evidence of the remaining prosecution witnesses, apt to reproduce the order dated 22/12/2023 passed by the trial court. Quote unquote A. This you will get it here. I am putting this. Hey, okay. The yellow flag, yellow flag. Okay. So, see, and I have, you put the whole thing, okay, with the name A to A. Interestingly, after the passing of the said order, one prosecution witness, though turned up on the next date, I 5/1/2024. However, thereafter, till date, the remaining prosecution witnesses have not turned up before the trial court. The aforesaid events clearly indicates the fault on the part of the prosecution in delaying the trial, consequence of which the petitioner has been languishing in jail for the last 3 years, 10 months, about 19 days. Speedy trial is a necessary concomitant of Article 21 of the Constitution of India. Any infringement of the fundamental right guaranteed to the any infringement of Article 21 right, 21 Article 21 of the Constitution, comma. Please delete that. In the event violation of Article 21 of the Constitution is established, statutory requirements shall not be applicable. That apart, the argument of Mr. So-and-so to the effect of applying Section 436 capital A in order to curtail, in order to construe, in order to calculate as what would be a maximum period for a accused facing trial from the custody would, in the opinion of this court, would be justicing the fundamental protection guaranteed under Article 21 of the Constitution of India. Reference is made to the decision of the apex court in the case of Husinara Khatun versus Home Secretary, State of Bihar, reported in 1980, Volume 1, SEC, at page 81, where the Apex Court, wherein the Apex Court had clearly held that the right to speedy trial of offenders facing criminal charges is implicit in the broad sweep and content of Article 21 as interpreted by the court. In the aforesaid judgment, the Apex Court further observed that the procedure prescribed by law for depriving a person of liberty cannot be reasonable, fair, or just unless that procedure ensures a speedy trial for determination of the guilt of such person, and that no procedure which does not ensure a reasonably quick trial can be regarded as reasonable, fair, or just, and it would fall foul of Article 21. Reference is also made to the decision of the Apex Courts in the case of Rabi Prakash versus State of Odisha, reported in 2023 SSC Online SC 1109. Wherein the Apex Court, in the context of an bail application in relation to an offense under the NDPS Act, has held that the conditional liberty guaranteed under the conditional liberty don't say conditional, the fundamental right guaranteed under Article 21 of the Constitution must override the statutory embargo created under Section 37, 1B2 of the NDPS Act. In a case of, just before that, where I said in relation to an offense under Section 20B2C of the NDPS Act. Okay. Apt to reproduce paragraph 4 of the said judgment, quote unquote. Reading of the aforesaid judgment, it is clear that the Apex Court Apex Court has held that the
condition under Section 37 of the NDPS Act as regards formation of opinion as to whether there are reasonable grounds to believe the accused is not guilty shall not apply in a given case where the accused has suffered prolonged incarceration notable to no, it is worthwhile to note that in the case in the facts of that case, comma, the accused had already spent more than 3.5 years in custody. Reference is also made to the decision of the coordinate bench of this court in the case of Lalpian Maui versus State of Assam, reported in bail in bail application number 3068 of 2024. Paragraph wherein the coordinate bench of this court, after noting various decisions of the apex court, has held as under, quote unquote, paragraph 14. And then 15, okay, 14 and 15. In the backdrop of above, don't say in the backdrop. Keeping the aforesaid principle in mind, comma, this court cannot be unmindful of the fact that when did the what is the date when the trial started? Which date? Uh, 23 that since 23/12/2021, comma, the date on which 15, that is the first date, but charge was not framed. That charge was framed when? This reframe it like this. This court cannot be unmindful of the fact that despite the trial court having framed charges way back on 23/12/2021, comma, out of the 9 prosecution witnesses, only 2 has been examined till date. Consequence of which the petitioner has been languishing in jail for the last 3 years, 10 months, approx 19 days. This is total, sorry, 1 second, huh? This is sheer violation of the fundamental right guaranteed to the petitioner under the Constitution. Hence, I shall be failing in my duty if the petitioner is not released forthwith. Accordingly, the petitioner, yes, what is his name?
Gautam Rai.
Gautam. Gautam Rai, huh? So and so is allowed to be enlarged on bail on furnishing a bail bond of rupees. How much? Of 1 lakh. He suffered a lot because of your 50,000, not 1 lakh. 50,000 with only with 2 local sureties of the like amount to the satisfaction of the learned. Is it? Huh? Are you sure? Please verify that. Additional Session Judge Rangya. One sec, let me just verify it from here. It says special judge. Additional special judge NDPS. Mr. Counsel, can you please write it down and give it to the stenographer? Please don't make a mistake there, huh? He'll give you the name, huh? Subject to the following conditions. From here, you can say. The number 1, the accused petitioner shall not leave the territorial jurisdiction of the which police station? Territorial jurisdiction of what? Guwahati, Kamrup, of Rangya, of the. He's a resident of. These conditions I will give it disposed of. Before parting with the records, this court pen down its dissatisfaction as making unnecessarily long arguments in bail applications, inasmuch as 1 day delay also is damaging the liberty guaranteed to the accused petitioner.